Bloom.
And I'm Sarah Bloom.
And today I want to talk about how we can win cases for workers even when employers come up with pretty good legal reasons to fire them. And stay tuned to the end for a quick, plain English summary of a brand new Supreme Court decision that just came down that, shock of all shocks, actually gives workers a major boost when they fight back. I did not see that case coming. Did you, Sarah?
I did not. You know, RBG and I are best friends. We met one time and I forgot my own name, but I really would have expected her to text me about this because it's a big decision.
You know, I never met her. You and my mom went and I did not get invited.
Oh yeah, I was there with Grandma. We had such a fun time.
Yeah.
Good times.
My invitation must have gotten lost in the mail. So most of our cases are about wrongful termination. That's the legal term.
So that legal phrase, wrongful termination, what does that actually mean? Can you give us some examples?
Yeah, so that means somebody is fired in retaliation for complaining about something like sexual harassment, or they standing up against discrimination in their workplace, or they're whistleblowers about unsafe or illegal conditions in their job, or asking for a reasonable accommodation for a disability, and then they get fired. Those are all illegal activities, and a worker can bring a lawsuit for wrongful termination under various state and federal laws, and that's what we work on when we represent people. And I want to tell workers that even if your company calls it a layoff, because a lot of people are getting laid off right now during the COVID crisis, it still might be a wrongful termination if your boss did not follow the rules.
So we do these cases every day, and unfortunately, you know, defense attorneys don't just say, everything you're saying is right, we'll give you everything you want. So what do companies say usually when we bring these claims as a defense?
So the defense attorneys always have to come up with something. They have to earn their keep, right? And what they come up with is a performance issue, what the law calls a legitimate non-discriminatory reason for the termination. So they're going to try to find something when somebody complains, right? They're going to scour the personnel file looking for a write-up. They're going to talk to the former supervisor and try to find some job performance issue. They're going to even talk to your coworkers and see what they can come up with. So the case almost always ends up being a battle over what the real reason was for our client's termination. And here's an example. We have a lovely, lovely client, one of our favorites. Her name is Elizabeth Taylor, not the movie star, although she's beautiful enough to be a movie star. But she's a young woman who worked in a company here in Los Angeles a couple years ago. And she says that her boss sexually harassed her. He grabbed her butt. He showed her hardcore pornography in the workplace. He even picked her up by her ankles one time when she was wearing a dress and exposed her underwear to her coworkers. And she objected to all of this. And she says that she was fired because she just didn't want to go along with it. Well, we went to trial last year, Sarah and I and some others in the firm. We did this trial last year, and the defense said, no, that's not why she was fired. She was fired for performance reasons, that she was late for work or she was absent from the office at times. Now, I want to make it clear, she denies all of that. She says it's not true. But even if it was true, it doesn't just mean that the defense wins, because the jury has to sort this all out based on the evidence and the witnesses at trial.
So, you know, nobody's perfect. What if both of these things are true? What if, you know, sometimes you're late for work and also the boss is sexually harassing you? How does the jury sort that out?
Right. So in reality, both can be true. Humans are complex and most employees have some job performance issues. Nobody is perfect.
Except me.
except my perfect daughter. So I always say, and I said in the 2 trials that we did last year, you know, an employee does not have to be perfect to bring a sexual harassment case or a wrongful termination case, because if that were the standard, nobody ever could. And the question is whether the worker's objection to sexual harassment, Elizabeth saying no, making it clear she didn't like it, whether that was a substantial factor in her termination. It does not have to be the only factor, just a substantial, a significant, a real factor. And that's a fair standard, I think. And California law is generally much better for workers than federal law. But in every state, there are laws protecting workers. And the U.S. Supreme Court issued a really delightful ruling in a brand new case that I did not see coming. And that case is called Babb versus Wilkie.
Hold up. Are you saying that the conservative majority Supreme Court with two Trump appointees, Gorsuch and Kavanaugh, handed down a ruling that's good for employees?
Yes. Can you believe it?
I cannot.
Knock me over with a feather. And, you know, amidst all the bad news that we are hearing every day, I really want to tell everybody about this good news for workers. And by the way, RBG, Ruth Bader Ginsburg, is still on the court at 87 years old, still working out daily, according to her trainer. So it's not just the Trump.
Better than me.
I know. And she does planks probably better and longer than me. And my other favorites, Breyer and Sotomayor and Kagan, they are all still there too.
So hypothetically, if some of us didn't read the case because we were downloading snap filters or photoshopping photos of ourselves with Andrew Cuomo, what did the case say?
That's especially funny because I know you're allergic to cats. Okay.
Not this one.
So what did the court rule? All right. So Babb v. Wilkie, it was an age discrimination case under a specific law that helps federal workers. Norris Babb, which is a great name. Norris Babb was a pharmacist at a VA hospital. Norris is a she says she was passed over for promotion because of her age. She was born in 1960, a year before me, so she's obviously very young and vibrant. She says that they discriminated against her based on her age, and the VA said no, they had legitimate reasons, and they said that Norris had to prove that age was a but-for cause of their failure to promote her. Now that's a legal term that we know. But for her age, she would have gotten that promotion. In other words, they said age has to be the decisive determining factor, which is a really high standard and hard for workers to meet. And Norris said, no, she said that the law required the VA's decision to be free from any discrimination based on age. Even if that was a little bit a part of the decision, that would be illegal. And you know what? She was right. That is what the law said. And even the Trumpy U.S. Supreme Court had to agree with her. And they said that in her case, the standard is that the decision could not take her age into account at all, even if they had other reasons for their actions. If they took into account that prohibited factor of age, then it was illegal.
Good for you, Norris. You go, Norris.
And you know what? If I were on the court and I look like this, I too would have ruled in favor of Norris. So I'm just saying.
Good to know.
You're not the only one who could do snap filters.
So how does Norris's win affect everyone else? What does this mean for everyone?
So this case, now it only applies to federal workers, but there are also many other laws to help all kinds of employees, federal, private, public, state, etc. Which is why if you have any kind of a wrongful termination case, you should talk to an experienced employment lawyer so you can find out what your rights are.
Now, Lisa, do we know any experienced employment lawyers?
Gosh. I don't know. Do you know anybody?
No one in my family is a lawyer, so I'm kind of
yeah, you were doomed to sit. Yes. You know what it says on Sarah's birth certificate?
Oh God.
Sarah Bloom S. It's a lawyer joke. Okay, so seriously, when we're not goofing around, we are always here. We are working remotely. We are happy to talk to you for free and confidentially about your situation. So remember, everybody, you do not have to have a perfect record to stand up for your rights and win your case. That's the takeaway from today.
Until our next Bloom Zoom, stay strong and stay safe, everyone.
Bye-bye.